I'm going to read the introductory part and the analysis part. So on the 9th of October 2024, the advocates for the parties in petitions E522 of 2024, E509 of 2024, E537 of 2024, E528 of 2024, E524 of 2024, and E506 of 2024. Yes, appeared before me for directions in aforementioned matters which relate to the impeachment process of the Deputy President of the Republic of Kenya. The court allowed the advocate to submit with a view to assisting the court to fashion appropriate directions to make in respect of the cases without delving into the substance of the application and the petition. As part of those submissions, two issues prominently featured: the empanelment of a bench to hear the petitions and an application to transmit the files to the principal judge of the High Court for consolidation of the matters. The petitioners who had made the application for empanelment were petitioner number in E509 of 2024 and the petitioner in E522 of 2024. Their applications for empanelment were vehemently opposed by the respondents. For context, it is necessary to indicate the petitioner in petition E509 of 2024 and who was represented by Mr. Degwanjiro, and in prayer 6 of the notice of motion dated 30th of September 2024 sought an order in the following terms, and I quote, that the matter be certified as raising weighty legal issues and the same be remitted to the Chief Justice for empanelment of an even number of judges for hearing and termination of the petition. In petition number E522 of 2024, the petitioner had similarly included the prayer in the notice of motion dated 2nd of October 2024 as follows: that upon inter partes hearing of the application or such other time as the court may determine, this Honorable Court be pleased to certify this matter raises questions of great general public interest for empanelment of a bench of an even number of judges for hearing and determination. End of quote. I will not go through the petitioner submissions which are in the ruling and also the submissions by the respondents, so I'll go straight to the analysis and determination part. From the submissions of the advocates herein, the two issues which arose was whether I should forward these files to the principal judge of the High Court based on Section 6.1 of the High Court Organization and Administration Act, Cap 8C, Laws of Kenya, and number two, whether I should certify this matter to the Chief Justice for empanelment of an even bench to hear and dispose these petitions. On the first issue, it is important that I set out the provisions of Section 6.1 of the High Court Organization and Administration that the respondent cited as the basis of the application for this court to transmit these files to the principal judge so that it may be consolidated with others that they alleged are similar. Section 6 states as follows: the principal judge shall be responsible to the Chief Justice for the overall administration and management of the court. B, ensuring order and proper conduct of business of the court. C, the constitution of benches of two or more judges in consultation with the Chief Justice. And D, undertaking such other duties as may be assigned by the Chief Justice. The above section that the respondent cited in urging that I should transmit the files before this court to the principal judge, based on allegation that there are other matters raising identical issues, is in my view inapplicable as it relates to general court administrative responsibilities bestowed on the principal judge, where the issue of consolidation is a pure discretionary function that rests on the particular judge and exercisable depending on the facts and circumstances of every case. This court is not persuaded that without the benefit of looking at those other files, this application is meritorious. This leaves me with the second issue, which is whether this court should certify this matter to the Chief Justice for empanelment of an even number of judges to hear and determine. Article 165, sub-article 4 of the Constitution makes provision for empanelment of a bench by providing thus: any matter certified by the court as raising substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice. Article 165, 3B or D of the Constitution has been delineated in Article 165.4 as constituting areas from which substantial questions of law might arise to require the composition of a bench. The two specific areas relate to the following: B, jurisdiction to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened; and D, jurisdiction to hear any question respecting to the interpretation of this Constitution, including determination of whether the question of any law is inconsistent with or in contravention of this Constitution. Number 2, the question whether anything said to be done under the authority of the Constitution or under any law is inconsistent with or in contravention of this Constitution. Number 3, any matter relating to constitutional powers of the state organs in respect to county governments and any matter relating to constitutional relationship between levels of government. And number 4 is a question relating to conflict of laws under Article 91. The phrase substantial question of law is not defined in the Constitution. In the case of Harrison Kenyajui versus Attorney General 2012 EKLR, the court stated as follows. A matter may raise complex issues of fact and law, but this does not necessarily imply that the matter is one that raises substantial issues of law. Judges are from time to time required to determine complex issues, yet one cannot argue that it means that every issue is one that raises substantial questions of law. Thus, there must be something more to the substantial question than mere novelty or complexity of the issue before the court. It may present unique facts not plainly covered by the controlling precedents. It may also involve important questions concerning the scope and the meaning of the decisions of the higher courts or the application of well-settled principles to the facts of a case. End of quote. Likewise, the court in Philomena Mbete Mwilu versus Director of Public Prosecution observed as follows. A question of law would be substantial question of law if it directly or indirectly affects the rights of the parties. There is some doubt or difference of opinion on the issues raised and that the issue is capable of generating different interpretations. If, however, the question has been well settled by the highest court or the general principles to be applied in determining the question before the court have been well settled, the mere application of those principles to a new set of facts presented in a case before the court would not on their own constitute substantial question of law. There must be possibility of a matter attracting different interpretations or opinion in its interpretation or application of principles espoused in the matter to make it a substantial question of law. All this notwithstanding, it is up to the individual judge to decide whether the matter raises a substantial question of law for purposes of reference. The court also dealt with that question in the case of Okia Omtata Okoiti versus Anne Waiguru, Cabinet Secretary, but I will not go through that now. It's a long excerpt. You may have to read it for yourself. I listened attentively at the issues in contention in these petitions as they were being canvassed by the parties' advocates. On the issue of the constitutionality of standing orders, the respondents strongly oppose the contention that this amounts to substantial question of law because such issues have been litigated before, including constitutionality of statutes by single judge, and thus is not a novel question warranting the referral of this petition to the Chief Justice. I was, however, keen to pick out the unique challenges pointed by the petitioners in assailing the standing orders that the National Assembly particularly relied on in carrying out the impeachment process. The petitioners pinpointed various concerns. The limited duration of 7 days to carry out the entire process was cited as having an inhibiting effect on carrying out adequate and meaningful public participation. The failure by the standing orders to integrate or provide for any mechanism for public participation and or a framework to credibly authenticate the outcome of public participation process were some of the issues that the petitioners raised as requiring serious circumspection, considering the fundamental position public participation occupies in providing continuous legitimacy to the actions of those charged with the exercise of delegated sovereign authority under the Constitution. Considering the immense public interest that this matter has generated, and being the first of its kind in Kenya where the Deputy President of the Republic is being removed by process of impeachment, it is my considered opinion that this matter deserves the input of a bench so as to pronounce itself on the process that is constitutionally compliant to serve as a benchmark for future undertakings of this nature. It is necessary for this citizenry of this country to know whether the current state of law allows adequate opportunity to participate meaningfully in the process of removal of their Deputy President. There was also the question of whether the allegation subject to an impeachment should be circulated to the public should be circulated to the public with or without the response of the person being impeached, and if the absence of including the response that if the action of including the response compromises the public participation outcome by prejudicing the person subject to the impeachment process through infringement of his rights to fair administrative action and the right to a fair hearing under Article 47 and 50 of the Constitution. These are substantial questions arising out of this impeachment process. The question whether the current parliament is properly constituted and thus incapable of carrying out the impeachment process in the light of Supreme Court Advisory Opinion Number 2 of 2012 was also highlighted. Finally, that notwithstanding the voting in terms of numbers in both the National Assembly and the Senate on the impeachment motion, if the jurisdiction of the court under Article 165.3 extends to interrogating the material relied upon under Article 45 and Article 145, so as to determine if the threshold to support the allegations was established either in the National Assembly or the Senate or both. I find that given the extensive nature of these proceedings, starting from the National Assembly all the way to the Senate and the massive public interest of the matters generated, it will require the mind of more than one judge to determine. In any case, it is not only the test of novelty that determines the consideration of the constitution of a bench, as courts do not exist to serve the intellectual stimulation of elitists, but to serve the public in matters of great concern to them. And this one is one of those rare occasions that the court should arise to the occasion and serve the public with all the resources that it can possibly summon. In my view, despite stiff opposition by the respondents, it is my considered opinion that these petitions raise weighty constitutional questions that fall under Article 163, B and D2. Hence, I am persuaded to refer them to the Chief Justice for empanelment of a bench. The lead petition shall be petition number E522 of 2024. The rest to be forwarded alongside this file to the Chief Justice are petition number E509 of 2024, E537 of 2024, E528 of 2024, E525 of 2024, and E506 of 2024. So that is the decision of the court. I believe the deputy registrar should be able to. I can give you a mention date in a not certain. Is it a week? Maybe you can mention it possibly on Thursday. I'm sure this is a matter that they would want to process first. Yeah?
Thursday this week.
Next
Next
week,
week.
yeah.
That is 17. 17.
Is it?
My lord, Thursday, 58, and also we're supposed to be in the Senate. So if an earlier date, we would appreciate it.
Well,
Lord, I think I understand the difficulty that we find ourselves in, but really your hands are also tied.
Yeah.
Once you refer to the Chief Justice,
I have no control.
yes, exactly.
Yeah, I hope that
will come and
the deputy registrar should be able to communicate once the file comes. You can keep on checking with the DR.
Yes.
Yes, I'll just keep on checking with the DR. Thank you.